All right, today we are diving into a really complex and, let's be honest, pretty controversial topic, legal paternal surrender. Now, you may have heard it called other things, like a paper abortion or a financial abortion. So what is it really all about? At the heart of this entire debate is one single philosophical question. When does consenting to sex automatically mean you have consented to parenthood? You see, the whole argument we're about to explore is that after conception, women have several legal off-ramps from that responsibility, while men, well, they don't. And that's the core tension right there.
So here's how we're going to break it all down. First, we'll look at what proponents call reproductive asymmetry. Then we'll get into the legal case for a paper abortion. After that, we're going to tackle the 3 most common objections you'll hear, and then the rebuttals to those objections. And finally, we'll look at what the ultimate goal of this movement actually is.
Okay, let's start with that foundational idea. Proponents of legal paternal surrender argue that the current legal system creates an unequal choice, and they have a specific name for this situation, reproductive asymmetry.
So what exactly is reproductive asymmetry? Well, it's defined as a legal disparity. The idea is that once conception has occurred, women have multiple legal routes to separate themselves from parenthood, while men, they effectively have 0. You really have to grasp this concept because it is the bedrock of the entire argument.
And this is where that argument gets crystal clear. On one side, you have the options for women after conception. There's abortion, there's adoption, there are even safe haven laws for relinquishing a newborn. And of course, there's the choice to raise the child. Now look at the other column. For men, if the woman chooses to have the child, his path is singular, financial obligation. It doesn't matter if he wanted to be a parent or not.
So it's this perceived imbalance that really sparked the whole call for a paper abortion, a formal legal process for a man to opt out. But to understand why this is such a legal tangle, we kind of have to rewind a bit and look at the court decisions that built the world we live in today. There are really 3 key moments you need to know about. It starts back in 1992 with Planned Parenthood v. Casey. That's when the court said a husband has no legal right to even be notified about his wife's abortion. Then, in 2005, a philosopher named Elizabeth Brake actually laid out an academic framework for this idea of a male right to choose. But the biggest moment, the real legal turning point, came in 2007 with a court case called Dubay v. Wells, which put the idea to a direct legal test. And the ruling in Dubay versus Wells, well, it's everything. It really gets to the core legal roadblock. The court basically said, yes, we see that the options are different, but legally speaking, men and women aren't in the same boat because of the simple biological reality that women carry the pregnancy. And that ruling was huge because it essentially cemented the idea that biological differences can justify legal differences in this arena.
So all of this leads to what proponents of the idea call a double bind. Think about it. A man has 0 legal power to stop his partner from having an abortion. But on the flip side, he also has 0 legal power to decline financial responsibility if she decides to have the child. He's essentially a legal bystander until the bill comes due.
Now, as you can imagine, this idea is incredibly contentious, and there's some very powerful counter-arguments against it. So let's be fair and dive into the 3 most common objections.
And for each one of those objections, we're going to look at exactly how the movement responds point by point.
Okay, let's break this down. First up, the big one, the best interests of the child. The objection is that letting men opt out financially would obviously harm the child and could put a bigger burden on taxpayers. The rebuttal to this is the claim that this best interest standard is applied unequally. Proponents argue that society already accepts a woman's choice for abortion or adoption, both of which also remove parental support from the equation. Second, biology dictates policy. The argument here is simple. Women are the ones who are physically pregnant, so their right to bodily autonomy is unique, and any legal inequality that results from that is just, well, natural, not discriminatory. The rebuttal here is to separate the 2 issues entirely. They'd say, we 100% agree on bodily autonomy, but a paper abortion isn't about the body. It's about legal and financial ties. And finally, the third objection, men should use contraception. This one's straightforward. If a man doesn't want kids, he should have taken precautions. The rebuttal calls this a double standard. They point out that when a woman's contraception fails, she has legal backup options. But when a man's contraception fails, he doesn't. And that, they argue, is the inequality.
So, after all the back and forth, the arguments and the counter-arguments, what is the actual endgame here? What are the advocates for this idea really trying to achieve?
According to them, the stated goal isn't to punish women or to harm children. It's to achieve what they call reproductive equity.
The specific proposal would be to grant men a parallel right to decline parenthood, both legally and financially, but within a very specific and early time frame, like the first trimester, to mirror the window when most abortions are available.
And that really brings us to the final, much bigger question that hangs over this whole debate. This isn't just about one specific policy. It's about a much broader idea. As our social roles, our family structures, and our technologies continue to change, should our legal definitions of rights and responsibilities evolve right along with them? It's a question with no easy answer, and that's exactly what makes this topic so compelling to talk about.